Hi, hello everybody. Greetings everyone. Welcome to the 18th International Conference on Artificial Intelligence and Law. My name is Lara Rocha Garcia, and this is the fifth panel of the third day of the event. Also, in the name of the International Conference on Artificial Intelligence and Law organization, I'd like to thank you, our platinum sponsors, JUS Brazil and Albert Einstein Israeli Hospital, and our gold sponsors, Logarithms, Legal Code, and PG Lawyers, and our silver sponsors, Urbano Vitalino Lawyers, Obsubum Lawyers, and Oasis Open. First, I'd like to mention our platinum sponsors. JUS Brazil is currently the #1 law and government website worldwide that makes high-value legal information easy and quick to access. Albert Einstein Israeli Hospital, our other platinum sponsor, is one of the best-known health units in Brazil and Latin America that is referenced in treatments with state-of-the-art technology and humanized care, expanding its borders with social responsibility actions, teaching and researching activities. Now, I would like to introduce Mr. Daniel Ho and Mr. Matthias Grabmeier, who will present the full paper, Context-Aware Legal Citation Recommendation Using Deep Learning. Daniel Ho is the William Benjamin Scott and Luna M. Scott Professor of Law at Stanford Law School, Professor of Political Science and Senior Fellow at Stanford Institute for Economic Policy Research. He's also Associate Director of the Stanford Institute for Human-Centered Artificial Intelligence, Faculty Fellow at the Center for Advanced Study in the Behavioral Sciences, and is Director of the Regulation, Evolution, and Governance Lab, RegLab. He received his JD from Yale Law School and PhD from Harvard University, and clerked for Judge Stephen F. Williams on the U.S. Court of Appeals, District of Columbia Circuit, who previously served as president for the Society of Empirical Legal Studies and co-editor of the Journal of Law, Economics, and Organization. Matthias Grabmeier is a tenure-track assistant professor of legal tech in the Department of Informatics at the Technical University of Munich, Germany. Before, he worked as a legal data scientist at the German legal informatics company Sync, and spent 4 researching and teaching at years at Carnegie Mellon University's Language Technology Institute. He obtained a diploma in law from the University of Augsburg, Germany, as well as an LLM and PhD from the University of Pittsburgh. Mr. Daniel Ho and Mr. Matthias Grabmeier, you have 20 minutes of speech. Afterwards, we will move on the questions. The stage is yours.
Thank you so much, Laura, for that introduction. And we're really delighted to be able to share this work with everyone at such an amazing venue. This is joint work with students at Carnegie Mellon, Zahan Charles, Mengqiu, and Hongyi, as well as a JD PhD student here at Stanford, Mark Krass. And we're really sort of excited to share this with you. The motivation for this work is the well-documented problems of mass adjudication. A less known fact about the US judicial system is that government agencies adjudicate far more cases than all the federal courts combined. Even a single agency like the Social Security Administration hears 500,000 cases annually. And that has led to really profound challenges in the administration of justice, where going back to close to 50 years to Jerry Mashaw's work, we know that the identity of who the administrative law judge is matters greatly, and in his view, even more than the facts of the case, such that award rates plotted here can range between close to 0% to 100%, depending on the assignment of the administrative law judge, leading some scholars to decry this as a form of disability roulette. This is what the file room of a recent mass adjudicatory agency in the American system, the Board of Veterans Appeals that we're going to study here, looked like as of a number of years ago. And so that came with really profound challenges, both in terms of the caseload, wait times for veterans exceeding 5 years from the time a notice of disagreement, a notice of appeal was filed until resolution. And here from some data that James Ridgway, who used to be at the BVA, presented, the result of this kind of increased caseload was that staff attorneys had about 10 to 15 seconds per page of the record, and veterans law judges with larger staff reporting to them had about 45 to 60 minutes for review per written appeal. Such that in 2018, a survey revealed that 90% of the staff attorneys reported having inadequate time to review the record. And that is really the kind of motivation for the kind of work we're doing here. It seems to have, where we're going to look at these BVA decision texts. So all texts from 1998 to 2017, about 750,000 decisions. And we're going to focus on single issue cases. And we're going to bring in some metadata from the internal system and also use the Harvard Case Law Access Project to combine and really figure out whether there are ways in which we can use advances in natural language processing to really help improve the accuracy and consistency of this process. For those of you who are wondering what VAICL stands for, it's the internal database that the Board of Veterans' Appeals actually uses to move cases along. And it literally stands for the Veterans Appeals Control object locator system, because it's literally the system that was used to try to figure out which room a file was located in. And so we've got basic information about claims and diseases spanning the years 2009 to 2017, and close to 300 identifiers for veterans law judges. And the basic way we're going to try to tackle this is to really see whether we can develop methods for better citation and application of precedent during opinion drafting, given the quality and consistency challenges in mass adjudication. So the kind of hypothesis, whether we can predict, build an ML system that really recommends citations that are specific to a case context. A little bit of motivation here is if you look at the existing kind of trends in large language models, if you turn to a model like GPT-2, you can prompt it with a statement like the following: as the preponderance of the evidence is against the claim, the benefit of the doubt doctrine is not applicable and the claim must be denied. And GPT-2 actually returns what look like pretty sensible sets of citations here that might be seen to support this statement. It respects the order of authorities as spelled out in the Blue Book. These look like roughly properly formatted sort of citations. The only small problem is these are citations to cases that don't actually exist. So there are still major advances that have to be made here. The actual kind of target would be Gilbert versus Derwinski for this particular statement about the benefit of the doubt doctrine. Similarly, another kind of example here would be a statement about material evidence. Material evidence means evidence that by itself or when considered with previous evidence of record related to an unestablished fact necessary to substantiate the claim. The kind of typical citation would be to the Code of Federal Regulations. And with that motivation, I'll turn it over to Matthias to talk about our technical approach to really solve this challenge.
Unmuting myself. Okay, thank you very much, Dan. I will present our technical approach now. And the first thing we do in our pipeline, so again, thank you for having us at this wonderful conference. It's a pleasure to be here. I'll present the technical approach. I hope my microphone's working. The first thing we do in this project in its technical pipeline is to pre-process the BVA decisions in our corpus. We do that using a comprehensive set of regular expression extractors that pull out citations to cases, the United States Code and the Code of Federal Regulations. We mask those citations in the text and forward the decisions with the masked citations to our tokenizer stage. Parallel to that, we take the raw citations that were extracted and apply a normalization procedure that resolves those citations to either the case law access metadata corpus, specifically the vet app and F3rd reporter. We also normalize citations to the United States Code and the CFR in a way that I'll explain in a moment, and hence assemble a comprehensive normalized citation vocabulary from which we draw the relevant citations and merge the decision back after having been, after tokenization. Okay. Okay, I'm getting a message that the video doesn't work. So
I see you now.
Okay, we're seeing. Okay, sorry. I'll just walk back to, thank you for the pointer. This is the graph I was supposed to be showing. So again, decisions come in, we extract citations, mask them, feed things into the tokenizer, in parallel, take the raw citations, apply our normalization procedure, and remerge those citations. Thank you for raising my awareness to this issue. To illustrate the citation normalization, we take case citations which we identify by the reporter name, the volume, and the page number, and we use case law access metadata corpus to identify a unique ID that we can resolve this case to, and all versions of referring to, say, Dekmatich v. Brown, are then resolved to this lemma. Citations to the CFR and the United States Code are decomposed into the prefix and the tail, where the tail is then segmented into individual elements. And so a full citation string becomes a list of normalized atomic citations. And using this procedure, we're able to boil down the 97,000 unique citations in our training data to about 4,300. 4,000 of which are normalized according to this distribution. We get a total normalization coverage of about 98.5% of the 5 million instances in our training data, which we think is fairly good. So the formal definition of our task is then to take a tokenized context segment from our decision, which may include already some special tokens such as paragraph breaks or other citations, and to predict in a delimited forecast window, the index of the next citation in theirs, in this case here, 132. As Dan has mentioned, this could be considered a text generation task. However, as we've seen in the example before, it's hard to generate full citation strings. So we treat this as a classification task, which is the slightly easier task to make incremental progress with. Of course, citation recommendation is a well-studied problem. For general and scientific literature recommendations, predominant approaches are collaborative filtering, graph-based and context-based models. There's also some work being done in the legal AI sphere, specifically often in conjunction with legal citation networks. There's also proprietary systems such as case text parallel search or Thomson Reuters quick check, etc. I'll refer you to the paper for details, but I do want to acknowledge the basic collaborative filtering and context-based approaches because this is what we are using in our model. As a baseline, we use a collaborative filtering model. So instead of one receiving, being a user and receiving, say, movie recommendations on Netflix, you are opinions here get recommended citations. To do that, we treat a case opinion as a bag of citations, which allows us to compute distance measures to other cases, and then additional recommendations are scored according to this distance metric. And the metadata Dan has explained is added using is aggregated using an SVM ranking module from which we then predict the citations. Our next model then adds textual context to it by representing the text preceding the citations as a bag of words in a TF-IDF vectorization, and we recommend citations by computing similarity from a query context to the contexts in the training data and the citations that follow them. Again, metadata is added to the model via as part of an input to an SVM ranking module. Our first full-blown NLP model is a bi-LSTM, which reads the citation context back and forth and gets its encoding concatenated with the metadata and fed into a classification head, which then predicts into the vocabulary size. Similarly, we take a pre-trained English pre-trained Roberta model, which is a stacked transformer architecture, which encodes the context, concatenates the encoding with the case metadata again, and feeds it into a classification head, which projects into the vocabulary size. This brings us to our results. So we evaluate recall at 1, 5, and 20. So the probability that our model predicts the correct citation in the top 1, top 5, and top 20 cite recommendations. And our primary results are in the neural models are for context sizes of 256 and forecast sizes of 128 tokens. The first thing we see here is that our neural models, of course, unsurprisingly, outperform our non-NLP models with recall at 1 in the mid-60s, recall at 5 in the lower 80s, and recall at 20 in the low 90s. We also observe that the Roberta model, despite being pre-trained, only does consistently perform better than the bi-LSTM model, but only by at most 1%, and usually within ±2 standard deviations across our 6 test folds. So pre-training, the limits of the benefits of pre-training are marginal here. What's also partially not shown here, and I would refer you to the paper for that, is that there is no the benefit of metadata influences training, but there's no consistent benefit in adding it in the different architectures. This is an area where we intend to conduct research in the future. And again, the details of the results that we observed are in the paper. If we take our best performing Roberta model and we run it over time, we observe that the model performs equally for case regulation, equally well for case regulation and statute citations, and also fairly stable across time with this little oscillation down here, we conjecture being due to a change in veterans law. We also observe the decline of the model performance as the distance to the citation in the forecast window increases. This decline is, of course, more sharp for recall at 1 than it is for recall at 5 and recall at 20. Still, so we do see some evidence here that the model is probably engaging in a fair amount of memorization of textual context, specifically for verbal and verbatim quotations of the sources before the occurrence of the actual citation. Still, the fairly gradual decline of recall at 5, which is sort of we consider the most representative use case scenario, suggests to us that the model does learn some amount of long distance patterns, and that it's a promising approach, technical approach, to treat citation recommendation, at least in part, as a classification problem and benefit from supervision signal, rather than treating it just as a pure encoding similarity retrieval model, a retrieval approach. Finally, we did an ablation experiment, and Mark Krass produced this graph here. First, please look at the right half here, where we compare models that predict 64 tokens into the future and models that predict 128 tokens into the future. So the upper quadrant is easy and the lower quadrant is hard. And we can see that if we give the model more context, larger context as we move to the right, the increased slope here shows us that the model performs better the more context we give it. And for the easier task up here, the more flat slope here shows us that for predicting 64 tokens ahead, giving the system more context doesn't help as much. The only other piece of information here before I hand it back to Dan is if you compare this to the left half of the model, of this graph, where we graph models that do not have access to metadata, we notice that if you are in the hardest task, which is you predict 128 tokens from a short context, actually, if you give the system metadata, so we're comparing these two spots, performance improves a bit, which means that if the model has to predict very far in advance and has little context, it may actually benefit from some metadata, but this benefit disappears more or less the more context you give it. And with that, I will hand it back over to Dan.
Great. if you just go to the next slide, Matthias. So we think we've shown the utility of this kind of a context-based citation recommendation system. And it's particularly notable that in the kind of more sophisticated models, the benefits to adding metadata were really kind of marginal. There are, of course, lots of other really interesting legal implications when we think about this kind of a system for AI-assisted adjudication, both in terms of the due process values and the decisional authority. That is, do you start to, for instance, reallocate decisional authority for locating relevant precedent away from the staff attorneys or veterans law judges toward the engineers who are building out a system like this, which of course relates to the much broader conversation that many of us are engaged in terms of algorithmic governance. If you go to the next slide, Matthias, I think the kind of concrete use case here really does come from the Social Security Administration, where Gerald Ray, who was head of the Appeals Council, had started to hire attorneys who also happened to have data science and software engineering backgrounds, had them learn the adjudication process, and then had them start to build out simple prototypes that led to sort of the first NLP-based error detection system, where staff attorneys and judges can input a draft decision and get around 30 quality flags, such as the one depicted here, that starts to use both heuristic and machine learning ways of spotting internal inconsistencies within the decision, like the one here. If you could go ahead and advance to the next slide, that, of course, then is what is one of the biggest kind of potential upsides to this kind of a system, is that one could go back to the original diagnosis provided by Jerry Mashaw of these kinds of NLP-based systems as really fostering better forms of bureaucratic justice in the kind of internal management system that Professor Mashaw had talked about, which connects to some of the broader work about the ways in which government agencies are starting to rely on forms of artificial intelligence to improve governance functions within the public sector. With that, we'll leave it open for questions. I think we can probably unshare the screen, and Lara, I don't know if you want to take over.
Hi, Professor Denhu, and hi, Professor Matthias Grabmaier. Thank you so much for your presentation. It's really interesting paper. Now we are officially open for questions. Until now, we don't have one, but I think I think our audience is just writing one. Just a second, please.
While that's happening, and maybe to give people a little bit of time to kind of get their questions together, Matthias, I think this has been just a really wonderful collaboration, because it's got kind of the direct collaboration both on the technical side and on the domain side. But maybe, Matthias, do you want to? One of the things we didn't present was sort of some of our thoughts on like next steps of where to kind of take a system like this. So I don't know, I'll throw a question over to you, Matthias, until we get a question from the audience. What do you think? What are you most excited about in terms of next steps?
Thank you. I also I'm very grateful for this great opportunity of collaboration, and everybody learned a lot over the course of this project. Technique-wise, there's of course a lot of things to be interested in here. Immediate next steps would be similar, Dan, to your group's other paper, would be to evaluate how much domain-specific pre-training would, for example, help models like this. The other thing we have been looking into is generalizing to the problem, again, now that we've established with some success that next citation prediction can be treated as a classification problem, can we make the task harder and move one step towards text generation in a way that does not suffer from the susceptibility to generate, say, implausible citations or other distractors that are not perceived as useful by the user.
Yeah, I would add one thing to that as well, which is concept drift, which is if there's a change in precedent by the Court of Appeals we have not yet focused on a system that really is able to detect that and to recommend substitution from historical precedent that, for instance, might have been overruled into new precedent. I think that's going to be a very important one to actually have a system like this operate in practice.
Okay, thank you so much. We now have one question from our audience, and they ask, Mr. Hu, could you please elaborate for us on how accessible this kind of technology would be for the use in countries that don't adhere to the common law? I think the audience is asking about the civil law.
Yeah, it's a great question, and I think probably Matthias may actually be better situated to answer that, since he does have familiarity with the German system. But maybe one thing I'll just start off in terms of an answer is that we may have glossed over this a little bit too quickly, but this is actually an interesting adjudicative scheme, because it's sort of has elements of the common law, but a lot of this is regulatory law. And so we had three different classes of citations: statutes, codified regulations, and case law. And so, you can kind of think of the task in a more civil law system as being one to kind of help adjudicators identify the right code provisions. And I think that's where a lot of the kind of pre-processing that Matthias described becomes really important. But Matthias, you have more familiarity with a different, a non-common law system. So I'd be curious to hear your thoughts on that.
Thank you. I agree with your first answer, and would like to emphasize this just a tad more, in the sense that our system is, in a sense, source agnostic by predicting solely based on use patterns. So we're not restricting it to cases, or it's not restricted in its current form to just cases or statutes or regulations. And in a civil law context, one could think about the fact that the system would pick up on common commentaries, for example, or other kinds of regulatory support documents, preparatory works, and so on and so forth, that would be cited in civil law context than you would cite precedents. So I think the basic architecture applies. However, I think it remains an open research question, or a sort of proof of concept question, whether legal reasoning that contrary in civil law countries, that contrary to common law, doesn't take as much recourse to specific facts of prior cases. So generally it will be more terse. There will be sort of less borrowed language and things like this, and less verbatim quotations. So the data distribution will change, but the basic task of predicting a source in a textual context will be the same, even if what's in the context will be a different kind of discourse.
Okay, great. We also have another question from Mr. Hannes Westerman. The question is, how the mentioned changing of precedents and maybe the discovery of new general principles of law may affect the processing of the tech? How the mentioned change of precedents and maybe the discovery of the new generation principles of law may affect the processing of the tech?
I think the way, at least I'm interpreting that question, is as related to what I had mentioned earlier to concept drift. That is, suppose there's a change in precedent by an appeals court. How does one build out a system and build out the architecture to ensure that it doesn't, for instance, keep recommending a case that has been overruled? And I think what would, of course, be I guess I have a couple of thoughts on this. One is that it would be very valuable to start to build in the kinds of citation signals that we see in, commonly used research tools for lawyers. But another really interesting source of information to exploit when those tags may not necessarily exist for a body of veterans law, for instance, would be to actually leverage the fact that there are are real quality differences in adjudicators. There are some adjudicators who pay a lot of attention to immediate changes in the law and are much more rapid in their adoption of new precedent. And that would be a very interesting thing to kind of explore, given that we see the identifiers of the different adjudicators, and could potentially start to understand which adjudicators are the ones that are signaling to you that the historical recommendations may no longer be accurate. Matthias, I don't know if you have other thoughts on that front.
I agree. So if you in the paper, there's a graphic which I'm not showing off in the interest of time, where we observe that it does not for many instances in the data, the system doesn't need a lot of training examples in order to predict the use with the citation with high accuracy, with high recall. So I do think that the data threshold of how much does something need to be there in order for the system to pick up on its use can be, depending on how varied the language is, relatively low. So I think we end up with this sort of cold start. So Dan calls it concept drift. From a machine learning standpoint, I sort of call it the cold start or sort of sudden stop problem, where something used to be, we should predict something up to now, and now we need to stop doing it. And we didn't see this before, but all of a sudden we now need to start predicting it. And I think this is in part where, and I agree with Dan entirely, where I think a merge of language-based pattern recognition, a hybrid approach of language-based pattern recognition with some intelligently curated metadata, structured metadata that is simple enough to be maintainable, but expressive enough to be useful for a model. I think that's where we want to go in the future.
Okay, great. We have more questions, but unfortunately we don't have more time. So your presentation is going to be streamed tomorrow, and then we are going to request or take all the questions that they made today and ask you tomorrow, and also the questions that they can make tomorrow as well. Thank you so much for your presentations. And now I would like to introduce Mr. Andrew Paley, who is PhD candidate at Northwestern University, and will present the full paper From Data to Information, Automating Data Science to Explore the US Court System. Mr. Andrew Paley, you have 20 minutes of speech. Afterwards, we are going to move to questions. The stage is yours.
All right, thank you very much. Thanks a lot for having me. Just getting set up here. And I hope that you are seeing my full slide deck. Is that true, Laura? Can you confirm? All right, well,
yes,
we're gonna go with it.
Yes, I can confirm.
Okay, great.
Yes, sorry.
Full screen, great. Great, so my name is Andrew Paley. Like she just said, I am a PhD candidate at Northwestern University. I work in the C3 lab, and I'm here today to talk to you about our paper, From Data to Information, Automating Data Science to Explore the US Court System. So the important thing here is, sorry, I'm having a bit of a technical thing, one moment. So to frame this, to step back and put a frame on this whole thing, the U.S. federal court system might feel like a monolith, and it might seem like one massive unit, but in fact, it's a tapestry of countless unique decisions made by individuals across hundreds of thousands of cases filed annually, as those cases work their way through 94 district courts, 13 circuit courts, and on up to the Supreme Court. Now, to get an understanding of what's actually happening in this court system, we have to actually be able to answer a series of questions. And those questions, and there are a lot of those questions, they include how often are fee waivers granted? Does it differ by district or case type? Do judges treat parties differently if they're self-represented, if they don't have legal representation? Do cases take longer in some districts versus others? Does that change by case type? Do judges nominated by different parties behave differently? And has any of this changed over time? And getting to the answers to these types of questions from the raw data produced by that massive system is in some part a technology problem, but it's also a problem of understanding domain. It's a problem of understanding the questions to ask. So the work we're doing and the work that we present in this paper is actually part of a broader initiative called Scales. And Scales is composed of about 24 individuals working across law, computer science, journalism, and social science at a host of different US institutions. And they're all working towards, we're all working collectively towards this one goal, which is to bring transparency to the systems and processes of the US courts, ensuring that they are fair, efficient, and accurate. There are different parts of this problem, and different groups within Scales are working on different pieces of it. But the one we care about and what's covered in our paper is how we go from the data, the information created by that system to the answers to those questions I presented a moment ago. Now, when we talk about data from the US court system, we have to at least note PACER. So the PACER system, the public access to court electronic record system, is paywalled. So this is how we get access to public records, the court records, but they cost money. It's 10 cents per page, maxed out at $3 per document. The result, in effect, is that analysis at a system level is prohibitively expensive. If you care about one case or 10 cases, getting the documents associated with that is not a big deal. You start to do system level analysis across tens of thousands, hundreds of thousands of cases, and it becomes too expensive to bear in most cases. That is not the focus of the work we do in this paper, but it is something that the broader Scales initiative is focused on. How are we getting access to the data from all the different districts, and also tracking pending legislation that's working through Congress to address this problem. But let's say we had the data. So let's imagine a world where all that data was actually available. You know, there's a version where we can sort of high five and we go home and we're happy with the fact that we made the documents free and we put them online. And that is a reasonable end state for a lot of open data initiatives. But you know, this is sort of the put it all online, let someone else sort it out approach to information access. And I don't think it's hard to imagine that if you went to someone who cared deeply about the court system, about justice in the United States, say a legal scholar, a lawyer, a journalist, and you handed them millions of documents and they wanted to understand something about the system broadly, they might feel like that's a relatively opaque form of transparency. So this is where the work that we cover in our paper actually starts. And so the big idea here is there's two hops in our paper. There's two tracks. One hop is from documents to structured data. And that is, that's what we cover here. And the other hop is how we get from data to the answers to those questions. But documents to structured data, what are we starting from? We're starting from 270,000 case documents, case dockets, excuse me. If you're not familiar with what those look like in the US, that's really just the overview of a case. So that's the district, the name of the case, the judge or judges, the parties, the type of suit, criminal or civil, the nature of suit, if it's civil, who are the lawyers involved, if the case is finished, what was the date terminated, and what was the outcome. And in between, the docket entries trace all of the events within a case. And those are unstructured text. Those are hand entered by people. They're different across districts. They can be different based on just the clerk entering them. So how do we go from that to structured data? A database of 25 to 30 tables. Takes extraction. We have to pull those HTML documents apart. It takes enrichment. So we're deriving a bunch of additional data points. The simplest example of that is case duration, where if the case has finished, We have a date filed, we have a date terminated, and on the way in, we're deriving, the length of the case in days and storing that. There's a host of other features we're deriving like that. It includes language modeling. By the way, all of this is covered in more depth in the paper, so there's plenty of details to dig into there if you're interested. The language modeling component, as we talk about in the paper, we're using to classify docket entries. So the early experiments are related to motions. We want to be able to track, if a docket entry is a motion, and then it's a motion of what type. From here, the ongoing work is classifying other types of docket entries. So orders, one example, responses to motions, case outcomes. And so that work rolls forward. Sort of implied by that is the notion that we are ontologizing cases, right? We're trying to get to the right layer of abstraction such that we know what tags to generate, what types of features to look for, so that we can create sort of the overall map, the contour of a case for the sake of case comparison. So this work is one thread under the scales banner. Like I said, the details are included in more depth in the paper. And it's the hop from documents to structured data. Now, there's a version of the world where we say, great, now we're done, right? We've done the work up front to go from these unstructured or semi-structured, this raw data, and brought it into structure. We've done the world a service, and we put that online, and people can now come and get the information out as they see fit. That step of getting the information out as they see fit, of course, takes one of two things. It takes skills or it takes resources. So skills, you want to make use of 25 to 30 tables with millions of entries. You need to know how to write code, create SQL queries, generate visualizations, possibly work with language models, etc. Or you need resources. You need to be able to hire someone that has those skills. This is like, data scientists as the human interface, or graduate students in some cases. So if you don't have skills or resources, then if you're a journalist or a legal scholar who actually wants to understand that data, to ask questions, to get the answers to the questions we looked at up top, then we get to a place where open data is actually necessary but insufficient. And this is true broadly. So we're talking about US federal court data right now, but any open data, open government initiative that stops at we've put the data online somewhere, now you go figure it out, is sort of half the battle. And what we really want is open information. And this is really what we mean when we say open data. It's sort of a proxy, but it's a halfway. So how do we bridge this gap then? How do we go from structured data to information? Well, what we're getting into then, just like the title of the paper suggests, is automating data science. And the goal for this second track of work we cover in the paper is that we want to empower non-technical users with the tool set necessary to drive data search and analysis without a data scientist in the loop. How do we do that, right? And that's what we'll be talking about through the rest of this paper now, for this presentation. Well, if we want to automate data science, we have to understand what data scientists do. And we're sort of rolling it up to 3 high-level buckets. No offense to any data scientists in the audience. Of course, there's a lot more to it than this. But the sort of interaction pattern starts from when a domain expert enlists a data scientist to dig into data. The data scientist needs to take stock of what's available and surface the space of the possible back to that domain expert. This is the data we have on hand. This is what we can do with it. They then can listen, have conversations with the domain expert, and translate the information needs, the questions, back to queries and analytics. And then when an answer is arrived at, bring that answer back and communicate it in a way that's clear to the domain expert. So if we want to automate that, if we're trying to build a platform that fills that role, we need a system that doesn't remove the complexity of data science or data analysis. It instead puts as much of the burden as possible on the machine. That is the Satyrn platform. That's what we're building in the C3 lab. We don't name it in the paper. We discuss it in detail, the version 1 of it. But the name, we've given it now Satyr. So the scales application, the demo I'm about to show you in a moment, is an instance of Satyr. And we'll dig into the particulars during the demo, but the things to take away at this level, looking at this bird's eye view, is that the user experience is what we call a natural language notebook. You might get the riff from Jupyter Notebooks if you're familiar with them. We're borrowing from the paradigms of data science tools, but instead of saying the inputs are code, we're saying those modular steps, that sequential data exploration, is now supported by simplified filters and plain natural language statements. The other thing to note as we go into this is that the system itself has nothing about any domain or data set hard coded in it. The query generation, the analysis engine, the search components, the API, and the front end, nothing about a particular data set. That's brought to the system through an ORM layer and an ontology configuration. I don't have time in the presentation to go deep on this. We cover the V1 in the paper, but the long and short of it is we need that specification of the database, the ORM, the list of tables and fields, and we need a little bit of metadata on top in V1. And this is stuff that abstracts away the schema and brings it closer to the mental model of a domain expert, someone who's asking questions, right? So this is stuff as simple as, it's not 3 or 4 fields that are strings in a particular table, it's a judge's name and they have a relationship to a case. So when a user says, I want to search by judge's name, they're not thinking about the particulars of the joins and the underlying fields, they're just entering some text and the system takes care of it. This also includes stuff like, it's not just a float, it's a case duration and it's measured in days. So where we're headed in V2 is collapsing this all down into a much simpler representation that looks a lot more like a standardized ontology with entities and attributes and relationships and a hierarchy. And that part is not in the paper. That's a matter of future work, but we're really excited about where we're headed with it. So demo, I'm going to jump out of this and move my share over. Okay. So I trust at this point you are seeing a web browser and someone shout if not. So what we're looking at now is a Satyr notebook. It's an instance though of the Scales platform. So the data that's loaded in is the data we've been talking about, right? This is case, these are case dockets. So if I open any of these up, I can dig around in the actual data of an individual case. But we want to support that, but what we care about most is asking questions across the whole data set. So let's collapse that data view. There are 267,000 dockets loaded in there, and I'm going to add a filter. The filters are, again, derived up from that layer of data semantics on top of the database. I'm going to say district. I want to look at the Northern District of Illinois. It's where I'm from, but also it's where we have the most data currently. So I make a selection and the filter updates. So now I'm looking at, now my data context has 104,000 case dockets in it. Let's ask some questions. So I'm going to add some analysis. The system asks, what do I want to know about? In the current iteration of the platform, we're presenting this as a sort of search or select dropdown, but it's, as you can see, it's not a great browsing experience. These statements are all the permutations of analysis that the system knows it can do, that it has inferred from states in the data, as well as what it knows its core analytics engine is capable of. So it's better to search than to browse. So I'll search for duration, and let's find out how long cases take in the Northern District of Illinois. So on average, they take 348 days. That's a really quick response to, search across or analysis across 104,000 cases. I can find out a little bit more if I want, a description of that metric, how it was derived, which again is pulled up from the underlying representation, and the data validation details. So the system will tell me, hey, you wanted to run analysis across 104,000 cases, but 6,000 of them actually didn't have a value that I could run an aggregation on, so I omitted them. We're still looking at an average across 95% of the data. And by the way, in terms of average case duration, that's just because the case hasn't ended yet. So we don't have a duration calculated. So now I might want to say, I want to know about that over time. How has duration changed year over year? Oh, gotta spell year right. I'll make a selection And this time, the system will respond with a line chart. And this is because it understands when I'm talking about something over time, a good way to present it is line chart. If I'm talking about a distribution, a good way to present it is bar chart, and so on. So now I've answered a couple questions. I get a sense of how case duration has changed year over year, and a little interactive chart. And now I decide I want to drill in more. So I can add a second filter. This time I want to look at cases with a nature of suit related to intellectual property. So I'll select that.
Really just 3 minutes last.
Yeah, I got 2 or 3 minutes and I'll be done. Oop. So property rights, that's what I wanted to search. So nature of suit, property rights, which I know is tied to intellectual property. And note that from that data context updating at the top, the questions below now update. So now with that additional filter, we see that cases go much faster when they're related to property rights. And interestingly, we see they sped up, right? And so from here, I might want to ask a whole bunch of follow-on questions. For the sake of time, I'm only going to ask one more. I might want to know about caseload per judge, right? And I could ask that question directly, but I could also break that caseload picture down by different dimensions. And so I will do cases per judge year over year, broken down by judge tenure. Let's see where that is. Cases per judge, group per judge tenure. Here we go. And so now I get a much sort of deeper portrait of the analysis. And I see that actually right about when those cases were speeding up, as I can see from this particular chart, that's when a whole bunch of brand new judges who had been on the bench less than 5 years, started to actually get those cases. So I can't go much further, but what I hope this is giving you is a sense that I'm able to explore the data very flexibly, apply filters, and ask a whole bunch of different questions in this notebook format without knowing code, without knowing SQL. And so just to wrap up, early results are looking promising. I trust you can see the slides again. Early results are looking promising.
Slides. Yes, we can see the slides.
Cool. Preliminary user testing across 15 subjects. We're actually in a second round of user testing now, but the first round, we had people complete tasks within the system. They came back, they filled out a survey. We got high ratings on usability. We got a 73 sus score, which is considered good usability. We detail these results more in the paper, and 87% responded that they would use the system frequently. Future work, there's a track of work on the data that involves more language modeling, more data enrichment, and blending of additional sources for court records, including state court, Supreme Court data, and then other sources like census data. And then future work on the platform involves expanding the analytics, refining the user experience, multi-data set exploration in one view, bringing new data sets through the UI, and a whole bunch of interesting things that flow out of that. In-platform language model training, which we'll get into in future publications, as well as expanding the purview. So we're bringing this to political data right now. We're looking at bringing it to education-related data and alternative user experiences. And so on behalf of the team on the paper, I want to say thanks, and I want to acknowledge the National Science Foundation for supporting some of this work.
Okay, great. Thank you, Professor Andrew Paley, for your great presentation. The first question that we have is that this system is available for testing.
We're actually working towards an open
for a
beta.
researcher from another country.
Yeah, so we're working towards an open beta, and I would encourage you. I flashed my email address right there at the end briefly. Oh, can you hear me? So we're working towards an open beta. I had my email address on the screen briefly at the end there, and I invite anyone to reach out to me. We hope by later this year to invite more users to take advantage of the platform in an open beta.
Okay, great. I think they will be anxious to use it. And the other question that we have is, in the paper, specifically in the future work section, what is the author opinion in the cited transparency in the US court system as a database of the proposed model? And what would be a rebound if the US courts decides in the short future to enter into an opacity instead of the stated transparency? Did you understand?
I heard most of that. I think so. Is the question related to whether if the courts were uncomfortable with this level of transparency? Oh, I see you added in the chat. Great, thank you.
Yeah.
Okay. So if the truth of the matter is that because of the way the data is, the way that the system is set up, court records are deemed public records. So the friction associated with the paywall is friction, but legally speaking, the court generates, as a part of our government, generates public records. So they can't prevent us entirely from having access. They can add friction to it. So that being said, there is an open question as we bring more transparency to the court system of how that will be perceived, and that is a conversation happening with the broader scales team. But we hope that is a positive thing across the board, that people realize that more engagement, more civic understanding is actually a net positive, regardless where you are in the system. I think we're having some technical difficulties, but I hope you all heard that answer.
Yeah, I have some technologies too. Sorry, I couldn't hear. If you could repeat the last part of your answer, if you don't mind.
I was just, oh, sure. I was just saying that they are in fact public records, and we hope that what the work we're doing is recognized as a net positive across the board by all members of the system. That transparency is a good thing, civic engagement is a good thing, that this is, after all, a democratic country, and we hope that the transparency is not seen as a threat, that we hope it's seen as a net positive.
Okay. Do you have any action plan to continue to be transparent and to avoid the opacity? Or do you believe that your model is already transparent?
So to avoid opacity, sorry. So do you mean like in our platform, once we have the data?
Yes.
Do you mean, okay. So providing the data very well could be part of the broader scales initiative. What I'm talking about is the platform that helps people take advantage of it, but absolutely, downloading the data directly, if people want to get their hands on it, that is part of the broader roadmap, getting access to just the raw data, if that's the nature of the question. I'm sorry, I misunderstood.
Okay, no, it's okay. Thank you so much. Okay, I think we don't have no more questions for this panel, so I'd like to thank you, Professor Andrew Paley, once again to give your presentation. In your paper is very, very interesting. Thanks so much.
Thank you very much for having me. I appreciate it.
Now I would like to introduce Mr. Devil McConnell, who will present the full paper, Case Level Prediction of Motion Outcomes in Civil Litigation. Devil McConnell is a second-year PhD student in the Department of Computer Science and Engineering at the University of Connecticut. Prior to my PhD, he received his Bachelor's of Science in Computer Science and Applied Mathematics at the University of Rhode Island. Mr. Devil McConnell, you have 20 minutes of speech. Afterwards, we are going to move to questions. The stage is yours.
Great, thank you so much. All righty, let's start slideshow. Okay. And sharing the screen. Share. Alrighty. So as we mentioned, my name is Devin McConnell, and this is the case level prediction of motion outcomes in civil litigation. So some background information. Lawyers regularly predict what courts will do and what to argue, when to settle, when to sue or prosecute, and when to reduce client liability risk. However, these predictions tend to be overconfident, not well calibrated, vulnerable to some bias, and advocating for a particular view. Therefore, recently, machine learning has been on the rise to aid in these predictions. In some scenarios, machine learning methods have been predicting judicial decisions with an accuracy that exceeds legal scholars. So using machine learning also has the potential for reducing litigation disadvantages faced by the poor, racial minorities, and other vulnerable groups due to court outcomes varying with the attorney quality and client resources. So one example of machine learning being used in legal predictions is the development of a random forest classifier on US Supreme Court data depicted here on 240,000 justice votes and 28,000 case outcomes. In 2004, machine learning was actually able to predict justice votes with a greater accuracy than legal experts, which is seen on the left of this slide. And then on the right, we're seeing machine learning being able to predict individual court outcomes with a greater accuracy than legal experts, split up by the category of that outcome. So the previously discussed methods focused on court opinions, which ignored many important formal procedures that lead to a final judgment and use features that are not available during litigation. In this work, we present machine learning methods that predict court outcomes at the level of individual motions. The goal of these methods is to provide client and lawyer support tools. We hope to reduce litigation disadvantages faced by vulnerable groups due to variability in the attorney quality and client resources. So here we are focusing on predicting whether a motion to strike is going to be granted or denied. And here I'm going to be showing Connecticut, and a motion to strike has a significant influence on a case's outcome and therefore is an important factor in legal decision making. In Connecticut, a motion to strike is a written petition for a defendant to a judge to remove part or all of a plaintiff's complaint allegation based on a legal insufficiency. So here we are providing an overview of the pipeline that we used for our work. And we computed two sets of features from the state of Connecticut's judicial branch court administrative database, which we're going to refer to as the minimal and subset features throughout the rest of this presentation. So this database contains administrative and procedural data for all civil court cases in Connecticut. These features were also combined with natural language features from complaint documents, and we then used a grid search to fine-tune the hyperparameters of the 6 machine learning models that we used. So starting off with the data collection of our pipeline, we used information from the court database that we had from Connecticut and the complaint documents we gathered as well. So starting off with the documents, many court documents are filed over the course of legal proceedings that are relevant to motion outcomes. We focused on complaint documents because they contain the facts alleged and legal claims that are asserted. They are available to all parties when a lawsuit begins and can therefore be used to support any decision making. For these complaint documents, we needed to convert them to text-based files so that we can use them during neural embedding feature extractions. So in the PDFs, if they contained images, we had to use Tesseract, which is an optical character recognition software maintained by Google. And we use this to convert images to text with higher accuracy. And when it only contained text, we used PDF to text, which could convert the text in the PDF to just a text file for us. And then we had the input from the court administrative database itself from the state of Connecticut judicial branch. These features are useful for the prediction of motion outcomes. And here I'm showing just a handful of the ones that we found useful. So case reference number and motion ID on this slide are ones that helped us map the cases to complaint documents, while case location is a one-hot encoded feature. Case major code, here we only use vehicular cases and tort cases. Motion result codes, we only used ones that were granted or denied, so GR or DN. And then motion filing party, we only use D for denied. And then motion juris number is just the attorney juris number for a given attorney. This feature also helped us create the attorney specialization feature, which will be described shortly. We ended up extracting 7,904 motion to strikes from the database. So all in all, we defined two feature sets from the database. So the first we defined as minimal, which contained the motion juris number and the attorney specialization. And then we also defined the subset feature, which contained case location, case major code, motion juris number, and the attorney specialization. It's also important to note that this data was pretty well balanced, with 54% of the motions being granted, 46 being denied, 47 being vehicular, and 53% of those cases being torts as well. And then moving on to the feature engineering, and we'll start off by talking about the attorney specialization. Attorney specialization is derived from the case distribution of major codes for each individual attorney juris number. Again, we are only looking at the torts and vehicular cases from the database. So here we use Shannon's entropy, whose probability vector is the relative frequency of major case codes. In this figure, we sorted the juris number on the x-axis by the entropy, and we see many lawyers have a high specialization, which means they have a lower entropy. But many of these cases are because we don't have much data for some of those attorneys. But to combat this problem, we worked on something to smooth the entropy with the Dirichlet multinomial, which is depicted on the right, which means we noticed that actually we don't have as many attorneys that are specialized as we originally thought. So the difference between using regular entropy and the smooth entropy can be viewed here on the left. So in this image, it shows many people being specialized, but it's because we don't have that much data to make a formal decision on whether they are specialized or not. So this could be because they only tried one or two cases in a specific area. But on the right, there's a Dirichlet multinomial smoothing out the entropy, which is controlling the variance of the entropy for the attorneys with small caseloads. We also built features based on the complaint documents. So rule-based features will map a condition to a class, where a condition is a group of Booleans for words in documents, and the class is a motion granted or denied. An example of this is if we have a complaint document, we can call it 1109, that contains car accident and negligence. And all of these words are also considered to be in the class denied. It would map to a label true, which means that this document is going to be a denied document. So we then took these rules that are learned by this classification during the rule learners to aid in our classification tasks later. So in this work, we also developed two versions of the rule-based learner algorithms, one of which is called the simple rule learner, and the other is called the first order inductive learner. So the simple rule learner algorithm is a greedy algorithm that adds a rule with it when it increases the accuracy of the model. So it counts up the frequency of the words in a granted document, which is going to be denoted here as a green box, and counts the number of the times that word appears in all the documents. And it also, we use a grid search to determine the threshold of when to pick a word to be either granted or denied. So in this example, as mentioned, we use green squares to denote a granted document, red squares to denote a denied document, and green highlighted words to denote whether the search term was a granted word. This means the word is a rule that maps documents to a granted motion outcome. So here, the simple equation is going to be the number of granted words plus 1 over the number of words appeared in all the documents for that term, plus k, where k is the number of classes you have. So here, our k value is actually 2. So our result for this is 4/6. So the other model is the first order inductive learner, which tries to balance information gain with the documents covered. Here we're keeping track of the number of complaint documents that are granted and the ones that are denied for a given rule. But we also need to keep track of the ones that are turned denied when they are originally granted and the ones that are turned granted when they are originally denied. So here we're denoting the granted documents as green documents, so green squares that only contain the green words, and red squares that only contain the red words for denied. And we can denote the documents that become denied documents as green squares with only red words. And the same goes for the denied documents becoming approved documents. So this means a green highlighted word is a rule that maps documents to a granted motion outcome. And in contrast to rule-based features, neural embeddings attempt to represent a higher dimensional document with a lower dimensional numerical embedding. So Word2Vec is a 2-layer neural network that takes a text corpus in as input and outputs vector representations of the words while trying to maximize the log probability of some word for some input word. While Doc2Vec is very similar to Word2Vec, instead of using just the one input word, you're taking a vector representation of that document to condition on. We also investigated a model called Law2Vec, which is a corpus-specific model of Word2Vec, and it used 123,066 documents that were on the United Kingdom legislative documents, European legislative documents, and several thousand English legislative documents. And to continue to make richer representation of the legal documents that we worked on, we investigated term frequency inverse document frequency, also known as TF-IDF. So you would do the term frequency multiplied by the inverse document frequency, where term frequency is the number of times the term you are looking for appears in a document over the number of words in the document. So here, the number of times the term appears in a document is going to be highlighted as pink, so 27 over the total number of words in that document is going to be 400. And you're multiplying it by that inverse document frequency, which is going to be the log of the number of documents in your corpus, which is 5 over the number of times that the word is contained in a document in your corpus, which is 2. So it's important to note that TF-IDF has shown success in natural language processing and aiding in increasing the accuracy of classifiers. And in recent years, TF-IDF has shown usefulness in corpus-specific weighting. And specifically with this, we'd see a weight of 0.027, which this weight would actually be useful to increase the accuracy score of our classifier, especially when we use it as a weight on a Word2Vec model. And it's important to note that a higher TF-IDF weight would represent a term that is in smaller amounts of documents, but more times, and a TF-IDF weight that is smaller is in more documents, less times. And then all three of these methods that extract information from Word documents are useful as standalone ways to improve your classifiers, but we can do better. So we can combine all three of these methods to make one method to increase the classifier accuracy. And we can do this by taking the TF-IDF weight and multiplying it onto our word-to-vec model embeddings that we extracted, and only using the rules that we extracted from the rule learner algorithm. So first we would do identifying the important rules from a rule learner, which for us, we identified that the FOIL algorithm was better off than the simple. And then we would only extract the word-to-vec embeddings from the FOIL list that was generated, and also only the TF-IDF weights from that FOIL list as well. We would multiply the TF-IDF weight that corresponds to negligence onto the negligence vector from word-to-vec, and then average out that vector for all of those word-to-vec, so that we would have one averaged out vector to create a document representation of our complaint documents. So now we'll talk about the parameter optimization and machine learning models that we worked with.
Devin McConnell, just 5 more minutes, please.
Okay. So we trained 6 models: AdaBoost, gradient boosting, extra gradient boosting, support vector machines, decision trees, and random forest. So a tree classifier aims to construct a hierarchy of decision rules that recursively splits the data until a leaf is reached that denotes the inferred class label, which is seen on the left. And then boosting is a general ML technique based on building an accurate learner from an ensemble of weak learners. This is similar to using an ensemble of tree classifiers with low depth. And then we also use support vectors seen on the right that tries to classify the data through solving a convex optimization problem, yielding a hyperplane that optimally separates 2 classes. We then optimize the parameters through a grid search using a 70-30 testing and training and testing split with a 10 cross-fold validation. And then to quantify variability in these fine-tuned models, we did 100 bootstraps. So to then figure out what version of the features we wanted to use versus minimal and subset, we wanted to quantify their difference. So here, just a refresher of minimal and subset. Minimal only had the attorney specialization and motion juris number, and subset contained motion juris number, attorney specialization, case location, and the major case code. And on the y-axis here, it's the motion classification accuracy, which is going to be the proportion of correct predictions to all predictions. And on the x-axis, it's our models, which again are the AdaBoost, decision tree, gradient boosting, random forest, support vector, and extra gradient boosting. So here we did notice that adding and using the subset features with case location, major code increased our accuracy overall. And we had the best performing with decision trees. So the median and mean accuracy on this model was 0.583. So we ended up only using the subset features for the rest of our results. And then we also investigated our 3 models across all different methods and compared it to a baseline classifier, which the baseline classifier had an accuracy score of 0.501. And just looking at the database features, we've noticed that the database features did score better than this baseline, but less than 0.6. And every time we added doc2vec and word2vec onto these database features, we did see an increase in accuracy score, but our best performing model was the one that had the FOIL, word2vec, and TF-IDF added on to the database features. And just so you know, as I mentioned before, the FOIL, word2vec, TF-IDF is the model that we averaged the word2vec weighted by TF-IDF from only the words that were learned by the rule algorithm. So this model gave us a 0.644 accuracy from our grid search and a mean of 0.605 from the AdaBoost model. And our decision tree had the best mean of 0.606. And we also tested the difference between predicting torts and vehicular cases for the database combined with FOIL, word2vec, TF-IDF. and noticed that SVMs were an outlier in being able to successfully predict the vehicular cases with considerable accuracy. Last piece of results here, we also calculated the feature importance from the decision trees, which feature importance is useful to let us know how the model's features contribute to predicting what we're trying to guess here. And here we're showing on the vertical axes the grouping of features from the TF-IDF, whether it be TF-IDF simple or the subsets. And then on the x-axis, it's the non-zero for at least one of those configurations. The last column is the sum of the word-to-vec features. And then we did note that major case code, attorney specialization, and word-to-vec have the highest average importances across the board. So then quickly to conclude, we did develop a pipeline that includes feature engineering rooted in legal domain. We also developed and benchmarked the first machine learning method to predict motion outcomes, also demonstrated that motion to strike outcomes are predictable with high accuracy when you use features for attorney specialization and with natural language processing. We believe that this can be useful to predict the survival rate of motion to strike with a complaint document, and believe that it can help parties to make more informed settlement decisions, as well as help rewrite complaint documents for better outcomes. And then our future work, we think better investigation in corpus-specific neural embeddings like transformer models such as BioBERT, LawBERT have seen great success, so that could be helpful. We also aim to expand this work to other motions like motions to summary judgment. Also hope to create a web interface for easier access and interaction to our models and for attorneys and clients. And then we hope to collect more data from surrounding jurisdictions and states. And we also aim to compare the results to a legal expert panel for our future work. And then just a quick thank you to the state of Connecticut Judicial Branch for providing us with our data, and my lab for the great support they've had over this past few weeks preparing, and my co-authors for the legal knowledge they provided and help with all the code. And if anybody is interested in this work, all the code is available at my lab's GitHub at Aguiar Lab Motion Predict. It has all of our rule learner, TF-IDF, word embeddings code to extract and combine the work, along with our grid searches, bootstrapping methods, and parameters for the models, as well as the models.
Hi, Devin. Thank you so much for your presentation. It's really interesting, and it is really useful to share your GitHub address. I think it will be nice to visit and to understand more about the model. So we have one question already. I'm gonna read for you. Just a question. Great work. I understand that relating the motion outcome to certain words. Could you elaborate more on how to select those words? I could imagine that some words would appear in both granted and denied cases. How would you resolve that?
Yeah, so the way we were doing it, we worked on developing oh, you sent it in the chat.
I just copy pasted the question, maybe it's easier. So, and it's a compliment about the work, and how do you elaborate, and how do you not appear when the granted and denied cases, when you resolve, how do you resolve that?
Yeah, of course. So what we did, we worked on looking at the two rule-based learning algorithms. So one of them, like I was saying, was the simple algorithm, and the other one was the FOIL-based learning algorithm. And of course, that does happen. Some of them do show up in the granted and denied cases. They're going to potentially show up more in one over the other. So we did perform a grid search to solve this problem to figure out what the best scenario is to determine if one is going to figure out the cut off of where this might be. So that's pretty much how we handle this, and using a testing and train split with a cross validation as well. So that was a 70-30 split with the cross validation of 10 as well for these.
Okay, great. If the author of the question have more questions, if not clarify, please, you can send us more questions. Until there, we have one more question that I'm going to copy paste here and read the question for you. How accurate can this kind of technology be in countries and legal orders or legal themes where jurisprudence is in constant change due to the new legal thesis?
That's a good question. I would imagine, I'm not particularly sure, I would imagine it should still hold up, considering there is work with United Kingdom legislative work as well as European legislative work. So I believe it should still hold up as long as people have similar court work, such as motions to strike and complaint documents. So as long as there is work along that lines, we are working to expand this to other types of courts as well. But I believe it should.
Yeah,
I'm not too sure.
I think, yeah, it's a difficult question. And I was wondering that when you said that the next phase of your project about your paper is to work with a legal panel, maybe it can be some hypothesis that you can work together, like trying to understand the different changes and the different legal themes.
Yeah, definitely. I'll have to keep that one in mind. So great question.
Great. I'm not sure if we do have any more questions. I don't think so. I'm just checking out. Okay, I think we don't have more questions, but you will still remain 3 minutes, 2 minutes now, if you want to do a closing with the final words. The floor is yours.
I think, yeah, so if anybody is interested, I can flash my last slide again for the GitHub, but we are definitely interested in people taking a look at our work and giving feedback if people are interested. So there's this, and yeah. So.
Oh, great. It's really nice. I think it's good to share this. So thank you very much for your presentation and for your participation in our Congress. And now I will just finish this panel with the 3 great presentations. Thank you so much for all the professors, Professor Dan Hu, Professor Matthias Greb-Mahir, Professor Andrew Paley, and Professor Devon McConnell. Thank you so much, and we are going to a short break. See you in a few minutes. Bye-bye.